Thank you very much, and good morning to everyone. We want to thank you for joining us today. We do acknowledge that the state of Florida is facing landfall of Hurricane Milton shortly here, and we truly wish everyone the best, and we want everyone to be impacted as minimally as possible and to be safe and secure. For those of you who are able to attend today, thank you. We are talking about a hot topic, the Federal Corporate Transparency Act. And just to let you know, this program is being recorded. Should you not be able to stay on, or should you have others that would like to watch after the fact, that it's recorded and you will be able to watch this in the future. So again, I'm Allison Hertz, and I'm here with my partners, Steve Mezzer from Tampa. Steve, thank you so much for being here today. Seeing as Milton seems to be definitely in your pathway, we really wish you to be safe in the storm. And David Ramsey, excited for David to be here, a practice group chair out of New Jersey. And since this is a federal law we're dealing with today, we are able to have our fellow attorneys from New Jersey. And thank you for the New Jersey attendees who are also attending. I don't usually get to speak with you, so that's pretty exciting. So again, we're talking about the Corporate Transparency Act, a new federal law mandate for basically reporting of information to the federal government, initially starting January 1. But we want to let you all know that this is not as scary as it's been made out to be. This is an administrative issue, and really, you should really have no problem complying, particularly after hearing this information and seeing us sort of run through the portal. So with that said, David, you're pretty expert on this topic. This is not really one that was supposed to grab associations. So what's this all about? Give us sort of like an overview of this law. How did associations get wrapped up into this?
Thank you, Allison. So for those who don't know me, and because we have a lot of people in Florida, I've been practicing community association law in New Jersey for about 40 years. I was previously the president of the Community Associations Institute. I still serve on its Federal Legislative Action Committee, which is relevant to what we're going to be talking about today. So in 2021, the federal government, in its ultimate wisdom, decided that it needed to adopt a law because they believed, with some pretty good evidence, that there was a fair amount of tax fraud, money laundering, and funding of terrorist organizations going on by small business entities. And this law is aimed at most small business entities. What does that really mean? Well, it means any organization where there was a filing with the state to create the organization, and which doesn't have both more than 20 employees and more than $5 million in gross revenue. If you do have more than $5 million in gross revenue, not net, gross, and you have more than 20 employees, which may apply to some of our community associations, then you're exempt from this law. You're also exempt from this law if you have tax exempt status under Section 503C, and there's various subsections of that code, of the IRS code. That only applies to a very small number of community associations, but there are a few. So if you're under that, you're also exempt from this law. If you don't fall into one of those categories, there's no automatic exemption for you. You are a smaller organization. Most of you have been created by a filing with the state, and therefore you are deemed a reporting company under the law. So I just to echo what Allison has already said, this is not medieval torture. You're not going to be put on a rack. But you do have to provide some information that we're going to get into in a lot more detail.
Yeah, and let me just ask you a few questions that we received
Sure.
from the attendees to get this out of the way. You mentioned the nonprofit is exempt, and those are
Tax exempt.
yes, those
Tax
are
exempt.
charitable organizations. A lot of our clients think that we're a not-for-profit, so we're exempt. No, there are two different things. You're a not-for-profit corporation, but that doesn't mean you're a nonprofit charitable organization. So we
That's
had
right.
a lot of questions on that. We also had a lot of questions just on these initial type, if you're eligible for this thing. Is there some kind of monetary threshold for associations to be mandated to report for this? And you did mention that small business income of, what was it, $5 million, but this is not.
Gross income, right?
This is not like the financial reporting requirement under Florida law where you have to get an audit if you have more than X number. No, I'd say 99.9% of the attendees here who are representing associations will be subject to this law and will have to report. So what does that exactly mean? Like, what do you have to report, right? And it's funny, when I was, researching this topic and looking into the form, it's kind of like any other online form out there. If you've registered for this class, if you filled out an application for a driver's license, an online job application, I just renewed my passport, much more difficult than this. So it's an online portal where you have to provide information about the association and about the beneficial owners of the association, which we'll get to more on that topic. Just quickly, one more thing here. So we did receive questions about, like, are we gonna have to report for our clubs and our committees and our sort of underlink and, of the association? And the answer to that is no in most cases, because as David mentioned, you have to be registered with the Secretary of State as a corporation or LLC partnership. Here, we're mostly dealing with corporations. So the answer to that is no. Clubs and committees do not have to register. So with that, I think probably one of the areas where we've received the most questions, and it's kind of more of the tricky area. Who is the beneficial owner of a homeowners association, of a condo association, of a co-op association that has to actually provide information as part of this registration requirement? Steve, tell us about beneficial ownership and how that relates to associations.
First of all, I'd like to follow up just a little bit on the
of course.
earlier commentary, because I think the most common question was, does it apply to us? And the answer is absolutely yes. If you meet those requirements that Allison was just referring to, you're registered with the Secretary of State. I have, for example, a few common law condominiums or unincorporated homeowner associations. They are not registered with the state. I do have two 501c3 corporation homeowner associations. They're not going to have to file, but everyone else will. And I think that's really, really important. Where I am over in Tampa, and I am evacuated, so you can see I'm a little hazy in the background here. I apologize for that. But in our area, we don't have any with the $5 million gross and the 20 employees, but I do understand that we do represent some country club entities and larger communities where that's what they do. They have $5 million of gross income and they've got the 20 employees, and they're also going to be exempt. But for the more common homeowner association, cooperative, timeshare, it's the board. Or if you have an owner who has more than 25% ownership, he or she or that entity would have to file. But more often than not, it's the board members. Unfortunately, our volunteers who give their time and their resources to be on the board now have to share this information. And it's just not that daunting. And once in a while, I get somebody who wants to push back going, well, I'm not going to share my information with them. Them is the government who probably issued you the driver's license number that you have to report, or your passport number that you have to report if you want to go that way for the identifying document. But it is also confidential on the government side. And I think we're going to get into some of the sharing aspects as we talk through the morning here. But the Bottom line is we're talking about board members, and that's the reporting end of it. So that's what we're dealing with.
So Steve, I mean, one of the questions I constantly hear is beneficial owner. Well, I don't own the association. Okay, I'm just a unit owner who agreed to voluntarily serve. What does it really mean to be a beneficial owner?
It's a control aspect,
Right.
making the decisions, and the board makes the decisions. Fortunately or unfortunately, that's the description, and that's where we have to put the responsibility for compliance. And I think it's also important that we recognize that this law was intended to apply to all corporations across the country. I saw a presentation with some other attorneys, I think it was about 2 weeks ago, and they talked about soybean farmers. And you think about it, we're not alone in this problem here. This burden that is put upon us to fill out this form is being shared by soybean farmers. So I think they feel your pain somehow.
And I just want to, particularly for the New Jersey attendees to this webinar, I've heard some attorneys, or at least it's been related back to me, that some attorneys said, well, just because you're on the board doesn't mean you're a beneficial owner because you have to exercise substantial control. And the fact that you happen to just vote on some things doesn't mean it's substantial control. Let me say this
Mhm.
about that kind of advice. That is a factual determination made on a case by case basis. We don't have the experience at this point to say, oh no, just because you're a board member who votes on something, that doesn't mean there's substantial control. Under almost all governing documents and almost under all enabling acts, the board has the authority to undertake all relevant actions on behalf of the association, putting aside those where the homeowners have to vote on something. So if it's not the board, I don't know who else would be deemed
Right.
to be in substantial control. So I just caution, particularly in our jurisdiction, anyone who
Yeah.
has heard that advice, be very careful about that.
I totally agree with that as well, David, that the board
Mhm.
makes the decisions. There's no one board member who's in control. And as this is untested, obviously, we did receive a lot of questions on this topic too. Like, is it just the president who has to be registered? No, it's all the board members. The board makes, the decisions for the corporation. Just to restate, because we're receiving a lot of pop-up questions now. There's an initial deadline for filing January 1, and then there's the continuing obligation to file should there be changes in the beneficial ownership of the corporation. And we'll run through the application really quick later, but just to put your mind at ease a little bit, that you don't have to provide your social security number as a board member. There's no personal financial information that's required to be provided. You don't even have to, indicate officer designations or positions on the form. So it's a very minimal information that's provided, which is name, date of birth, address, and a copy of your driver's license, passport, or other identifying document number. So there is no, other types of personal identifying information. So again, January 1 is the initial deadline for everyone. But then this thing actually, you have to keep updating it. And what I will mention is there's no fee to report. There's no fee for the initial report, and there's no fee to update. Because frankly, you kind of will have to update this thing somewhat frequently, depending on how much your board members change. I mean, some of our board members stay the same over and over and over and over. And in that case, maybe you won't have to change it so much. But in a lot of associations, there's contested elections or people move or resign. So David, talk to us about the continuing obligations we have here.
So first, Allison, I want to make the point that this is not an annual filing. In other words, once you filed once, if the board members all stayed the same, you don't have to refile every year. But as you're making very clear, and it's important to note, that the law has a very specific time limit within which you need to update information.
Mhm.
So if you have someone who passes away and you appointed a new board member, you have someone who resigns, you have someone who moves out of the community, you have an election and you have new board members, you have only 30 days to
Mhm.
go online and to update that information. So you need to be constantly cognizant of that, those changes. And even if you, for instance, let's say somebody had moved out of the community, but they still own
Mhm.
the unit, and now they're living somewhere else, their address is no longer what they
Yes.
formerly said. Maybe they got a new driver's license, and that was what they used as their identifying document. You have to update that information. So anytime the information you've provided, which is relatively minimal, as Allison has made very clear, but any of that information changes, the board members need to be aware that then there's 30 days to do an update on that information.
And we did receive, it was an interesting question.
Mm.
You know, what if my driver's license expired and I got a new one? I mean, that's an update. So you gotta
It
be,
is.
cognizant of these little nuances that would require an update. Again, the update's not the biggest deal in the world. It doesn't cost money. And I think the update will be rather quick. But I can understand this is concerning from a board perspective. How do you stay on top of this? What measures can you put in place, protocols to ensure that the association is in compliance? And I think there's various things that you can do. We've talked about, and Steve would want to kind of touch on that, or any other comments you have on that.
Yeah, for the typical association, the smaller ones in particular, may want to designate the secretary as being the keeper of this information so that he or she updates it. And as David pointed out, it could be anything from change of address to other candidates being elected or appointed to the board, the expired driver's license, in Allison's case, the expired passport, um, those kinds of things, so that you have that. But also, anybody else, if you are a management company, I might consider putting that in the contract that you will handle that information for the association so that somebody is designated to be responsible for it, because let's face it, it's going to be easily forgotten unless you are on top of it. So please do make it a point, whether it's going to be on your annual meeting, organizational meeting agenda each year, or something else, to make sure that you're up to date at all times.
Yeah,
And by the way, I just saw something pop up, and it's right on this point, which
Yeah.
is, what if you're a non-US citizen? Do you still have to file? And the answer is absolutely. And I also occasionally get the question, particularly in the age-restricted communities, well, I don't drive anymore. I don't have a driver's license, and my passport expired 5 years ago. I don't travel, so what am I supposed to do? Well, I know New Jersey will issue this. There is an identification card you can get. I assume Florida
Yes.
is similar out
Florida
there.
does the same.
Yeah. And
Mhm.
so you can get that identification card and use that, because it's a government issued form of identification, and it will have your picture on it, et cetera. So yeah.
Yes.
yes, that's a good point. As to, keeping track of it, you could also consider, having this as a standing agenda item at all board meetings. Like after roll call, you say, okay, has anyone's information changed? Maybe you don't want to have the director give it to you right then and there, but it's a reminder of some kind of periodic notices sent
Mhm.
by either secretary, manager, even perhaps designated some kind of assistant officer just
Yeah.
for purposes of this role. I mean, there are a lot of creative things that can be done to make sure that you can comply. So with that, I kind of wanted to share my screen and go into the portal at this point, if you think that's a good time. And let me see if I can do that, because I'm not the most techie, but I think I can do it here.
There you go.
Are
There
you,
we go.
are you seeing the screen?
Yes.
Yes.
Okay, wonderful. That was the first step here. So this is the FinCEN website where you will be able to file this report. And we'll be sharing the links to these websites after the program in a follow-up email that you'll get. But this is sort of like the home platform page where you'll go in. And here it says get started. It's rather easy. There are two main methods to prepare the filing. You can use a PDF document where you can, at the end of the exercise, submit it. There's no paper filings. You can use this in the event you kind of want to save things and come back to it. I actually prefer the online filing. I think it's more user friendly and it's more, I think it's just easier to deal with. You have, this is the home page, right? And it goes rather quickly once you kind of get the hang of it and go in and play around with it. So they're asking, number one, the type of filing. Here we have an initial report filing. And see, right here, you have a drop-down box with respect to many of the portals here that give you help, that if you don't understand a question, there's help right here. So this explains it. It's sort of like the annotations or the notes to each different section. So we have our initial report right here. And what I also find interesting, and I think Steve and I talked about this earlier, is that the federal government estimates that the burden associated with the collection of this information is going to range from 90 minutes to 650 minutes per reporting company, coming from an easy one to a apparently severely complex one. But I think it could even be done in less time than that. It kind of depends on the number of directors you have to input the information, how fast of a typer you are, and if you're computer savvy here, but it's really easy. So this is our initial report. Second box. And we have a lot of questions on this. Request to receive FinCEN ID. And again, this second box is with respect to the reporting company. That is your association, your corporation. This is part one regarding your corporation. So do you want your corporation, your association to receive a FinCEN ID? I don't necessarily think you need this. I don't think there's anything wrong with having your association obtain this number. Might make it easier for some future filing, but again, not required. We did receive a lot of questions and we'll get to that on FinCEN IDs for the beneficial owners, i.e. board members, which we have different thoughts on, but let's continue going here. Once again, you type in the name, Happy People Condo Association, Inc. And perhaps you have a DBA, which you call yourself Happy Condo Place. If you have no DBA, you don't include that. You'll see the red asterisks are regarding the required fields. Some of these things just aren't required. Form of identification for the corporation, tax identification type. Most of ours here, you're going to have the EIN number. That's on your corporate report, and you'll include your, apparently, I believe this is a 9-digit number here, and you'll get to move forward. Next, jurisdiction of formation of the corporation. If you need help, there's the drop down here. We're all in the US corporations, I would presume, and the state. Most of us are going to be Florida or New Jersey. So once again, very easy to fill out. US address, this is your principal place of business. And we did receive some questions concerning like, well, what's the address for our association? What's the principal place of business? And, my explanation of that is if you have a association address at your community, your office, your clubhouse, that would be your address. If your management company perhaps has allowed you to use their address as your principal place of business, perhaps you use that. My preference would be for you to use your clubhouse or your office address to the extent you have them. Some associations just don't have any kind of address that's not somebody's home. David, Steve, do you have any thoughts or advice there? Or?
I would go with the one that's on the Secretary of State. And yes,
Yeah.
it would be somebody's home, but whatever it is, whether, okay.
Okay, so you'll fill in all of that, and now we're off to the next screen. Okay, this we did have a lot of questions about, and this I will say is one of the more confusing ones, but it's probably not relevant. The company applicant is not going to be relevant to probably 99.9% of you. This only applies to corporations or entities formed after January 1, 2024. So most of those would still be developer controlled and not in the hands of you unit owner controlled, lot owner controlled members. So you would just click the box here that you're pre-January 1, and then you're moving on from that. None of this stuff applies. So here we get to sort of like the main show, right? Where we talk about the beneficial ownership information. You will start inputting the information here for each board member once again, and you can add additional board members, owners by clicking this tab right here. So there's not going to be just one of them. There's going to be at least 2 or 3 at a minimum, and probably more. I know some associations have, 9 or 11 or 13. Well, that's quite a lot in my opinion. But we did receive a lot of questions and inquiries regarding whether the board members themselves as the beneficial owners need to get this FinCEN ID. And I think there's differences of opinion probably here, but I think all of us here on the panel agree that, it's definitely and certainly not required, and it probably is not advisable for associations. This requires a 2-step process, basically.
Good.
It requires each board member to log into a separate portal to obtain the FinCEN ID. And then it requires each board member to give that to the secretary or manager or whoever's charged with completing this form. So now, as let's just say the secretary, you've been charged with completing this, and you're waiting around for every board member to give you their FinCEN ID, and you have, frankly, less control over it. And you just want to get this done. You don't want to have to be messing around with waiting on it. And I think for a lot of people, it would be a lot easier for each board member to simply provide this information that's requested, even a copy of the driver's license or passport or ID card to the individual who's going to complete the form, rather than have this 2-step process. See,
And as you pointed out, Allison, the red asterisks are what you must complete. There is no red asterisk next to the FinCEN ID. So that pretty much tells you you don't have to provide it.
So if you're not dealing with a FinCEN ID, this is the information that you have to provide. Again, it's not that much. Last name, first name, middle name, not required. Date of birth, right? I know some people get a little like antsy about giving their date of birth, but you're gonna have to give that and a copy of your driver's license. So address, and then typical address information. And
Is that residential, or can it be your office address, Allison?
I think this is the, address that's probably going to be shown on your ID. Agreed?
Yeah, although I've heard, my understanding is you could provide either your home address or your business address.
So going down here, once again, you're going to be, having these drop down boxes. So here, most people, I presume, are gonna provide their driver's license number, jurisdiction that they are in, et cetera, and then right here, you upload a copy of the driver's license showing the identification number, and that's it. I mean, it's really not that hard. So here you'll add another owner. So, but see, I click the box, beneficial owner 2, and you do the whole thing all over again for each board member. So let's say we did that. And now we're going to submit the information. It's not that many steps. You input the email address of the person who completed the form, and the first and last name, and the person who does complete it is required to certify that they're authorized to file it and that the information is true, correct, and complete. So you agree, and they're telling me that I don't have some of the required information, and that's it. So it's really not that scary. It's really, as you see here, very administrative in nature. It's just not that, I think it's not what people thought it probably was going to be. So let me stop sharing screen. I don't repeat that. So, with that said, now that you've heard about this and you've seen how really easy it is, you know, we've had a lot of questions about, is the firm going to do this? Is the management company going to do this? I used the secretary as an example, and perhaps maybe that's a smaller association, or maybe not, seeing how it's not that difficult. I think that everyone's going to be able to do this. It's administrative. We obviously are happy to assist clients in filing. I know David is happy to assist clients in New Jersey as well. It's basically whether there's really a need for it, right?
Well, I think that's right. And, you know, anytime you involve your lawyer, and even though this is just an administrative task, there is going to be a billing for this. And so, you know, for most associations, it just wouldn't make sense to involve your attorney in the filing. We're certainly available to answer questions. You get into it, as I think, Allison, you said, you can suspend your filing, but still keep it active. And then if you have a question, by all means, get in touch with us. We're happy to walk you through this. I know we also have a form that says, here's what you do. This is what you fill out. And we're happy to provide that to you. You know, if you absolutely need us, you know, we'll help you. But you shouldn't have to have us file this for you.
It's well said. Yeah, I agree with that, David. You know, we go to meetings, we don't take the minutes, we don't fill out the corporate filings for them. So this one doesn't go to the level of requiring legal assistance. It's filling out a form with your name, address, and your driver's license, things like that. We're trying to discourage people from hiring an attorney to copy your driver's license and file it with this form. But if you have a question, by all means, contact your Becker attorney and he or she will assist you.
We've received a lot of these pop-up questions during the presentation, in addition to the ones that were submitted prior. And just to make this very clear, this is not the same thing as your annual report with the state of Florida, you know, sunbiz.org. This is not the same thing as your annual corporate report for New Jersey. This is a completely separate filing required by the federal government, by the U.S. Department, administered by the Financial Crimes and Enforcement Network, a bureau of the U.S. Department of Treasury. So again, going back to the way beginning, this is to apparently combat terrorism, money laundering, and this is a federal requirement. This has nothing to do with your state requirement. If you know, a lot of pop-up questions. Well, if we register with Florida, is that good enough? No, it's not good enough. Once again, the initial deadline to file this thing is January 1, and we'll provide you with the website information. And then it's not an annual thing, as David mentioned. It's a thing, you know, to the extent your beneficial owners remain the same and all of the addresses and information for your corporation and your board members remain the same, you know, you don't have to update it. It's only when certain things change that you are required to update it within that 30-day period. And I know there's like some kind of grace period, which we'll get to a little bit later. So I felt the need to restate that, all of that. And, you know, with that said, getting back to the point we were making, you know, lawyers probably don't need to be involved in this. I think somebody already mentioned management companies. Shouldn't management companies be doing this? I think a lot of management companies are doing this, helping with the initial and reminding of updates. And, you know, let's face it, there is some potential risk to filing these reports, because if you provide misinformation, there is penalties, and we'll get to the penalties. So perhaps the reporting company, that's what they're known as in the law here, your management company would be, you know, this third party company. You want to make sure that you have an agreement with them to properly handle this. If you have some other type of third party vendor, you know, soliciting you to do this for you for a fee, take a good look at the agreement and have your attorney review the agreement, that's where we would get involved.
Yeah, that's a good point, Allison, because there are already, believe it or not, scammers out there that would take your information and not file it and do bad things. So you do have to be careful. do you consider your manager, your CPA, or one of those online providers and see who will do the best job? But if you do venture out of the knowns into the internet world, be very careful with that as well.
Somebody just asked, what are the fees? I mean, I think we've seen them, they're not pennies here. They're not, what legal fees could add up to, because those add up pretty quickly. So, I mean, I've seen some, what I would consider pretty reasonable fees.
But you got to do your due diligence, and I think that's the point
Yes.
Steve is making. You got to make sure it's a legitimate entity,
Mhm.
before you just do some searching on that company's name
Right.
and see if there's any bad news about that company before you just jump in and say, yeah, we'll give you $250 and so on. And keep in mind, for the relatively minimal fees, they're not going to chase you for the information. The information, the board members have to really be cooperative in this process. And that's an important point. They
Mhm.
really need to provide this minimal information, but somebody needs to be the one following up. And we all know that, these are one of those things you put at the bottom of the pile and you say, oh, I have until January 1. Well, January 1 is going to be here before we know it. So,
Mhm.
it's time to start accumulating that information now.
And as I mentioned, there's no fee to do this yourself. So if you're a cost
Mhm.
conscious association, we all know, with all the costs out there, reserves, insurance, everything. If you're trying to save, I don't think it would be unreasonable for you to designate a board member to handle this at no cost. It really doesn't take that much time. So, what can happen if things go bad? There are penalties associated with not filing, with failing to update and filing misinformation, willfully, right? A lot of the fines relate to willful violations, not just a mistake, but we gotta be cognizant of the penalties and fines and like worst case scenario, because that's of course what we live here with as attorneys. What could happen in the worst case scenario in the event that you don't comply or you provide incorrect information. We also had a lot of questions about what if a director refuses to give
Mhm.
you information? What do you do as the remainder of the board? Do you, just not file it? So let's talk a little bit about that. And first, what are the penalties here that associations and possibly individuals are dealing with?
Yeah, so they're not inconsequential,
Mhm.
and that's an important thing to realize. While this is not difficult to do, if you ignore it or you have board members who ignore it, there are possible fines of up to $10,000. There are possible prison terms up to 2 years. There's also civil penalties that are a per day penalty for not filing, which can, amount to an extraordinary amount of money. And those fines can go both against the reporting company, the association, as well as individual board members who don't comply. So the ignoring this law is a serious matter. And I know some of you might say, oh, well, won't my D&O carrier be responsible for that? No, your D&O carrier, even if they provided you a defense in a lawsuit, they're not going to pay the penalties and so forth that would come about. So this is serious stuff. Now, having said that, and this is not legal advice to anyone, but the general perception out there is that the government's not going to be tracking down everybody, on January 2nd. They're not going to run around looking for people. There's hundreds of thousands, if not millions, of corporations that exist that were covered by this act. They simply don't have the resources to do that. So the
Mhm.
likelihood, again, not saying this is definitely what will happen, but the likelihood is that if you're otherwise were to be caught, and I don't think any of our associations would fall into this, committing tax fraud, doing money laundering, financing a terrorist organization, and then you get caught that you didn't do the filing, this is going to be an add-on. This is going to be another one of those things that you're going to get that an organization that does that is going to get hit with. That is not to say don't pay attention to it, because you as a fiduciary cannot place yourself and your corporation in the risk of having that kind of liability. Now, if you do inadvertently make a mistake, and it comes to your attention that we're not talking updating now, we're just, you realize that you gave the wrong address or something of that nature, you have up to 90 days to correct that without there being any kind of a penalty. So there is that grace period put in. So the senior officers of the company, not only the reporting company, but those fines and so on, the senior officers of the company are also liable. That probably means whatever constitutes your executive committee, the president, secretary, vice president, etc. So anybody who's an officer, I think, would probably be the senior officer. And so going back to that question that Allison raised, what if you have a board member who refuses? And I think the answer might be a little different in Florida and New Jersey because of state law. I learned earlier this morning that there's a statute in Florida that's very specific about whether you can remove a board member. There's also a statute in New Jersey about removing board members, but it's much more liberal. The board can actually remove a board member for acting in a manner that's contrary to the interests of the owners in the association. And I would say to the degree that the corporation would be liable for penalties that the owners would end up having to fund, that is an avenue that you could use in New Jersey to remove such a board member. But Allison, Steve, I'll throw it back to you for what you could do in Florida.
If you address that, I mean, wow,
Yeah.
if that was the law here in Florida, things would really be different. But what do you say here in Florida?
Yeah, as far as the resistant board member goes, so far I've been hearing they're just resigning. They don't want to do it. I don't understand that, because all they're doing is giving their name, address, date of birth, driver's license. That's it. That's the extent of their participation here. And if they want to resign, so be it. It's a volunteer position. But after that, if I'm still dealing with that defiant, reluctant board member, I would probably encourage the board to ask for his or her resignation, try to separate ourselves from that board member so that when bad things happen, if they do, we have done what we could do to mitigate it. And to David's point about the insurance, because there is a criminal penalty here, insurance is not going to come to your rescue for anything criminal. So I would not count on that, nor would I count on the common law indemnification or statutory indemnification if you're failing or refusing to comply with federal law. So please be careful out there.
Yeah, and if you have somebody who's, hesitant or refusing to provide a board, one of the 5 board members, let's say, that doesn't mean you just sit on it. So I would definitely recommend completing for the 4 members and then perhaps convincing this holdout to provide the information. And then once again, do the update. It doesn't cost any money, just get it done. And, once again, we went through the portal. There's not that much information that's requested that would really be objectionable here. I suppose it could be the driver's license number or passport number or ID number and a copy. But, that same board member might not realize that in terms of screening the transfer of the sale when he originally came in, you might already have a copy of the license, or, a lot of associations have this information in other courses of like what they do. So I think that's something that might ease people's mind, that in order to get your clubhouse ID card, you might have already had to give a copy of your driver's license. But there are a lot of concerns about associations keeping and maintaining this personal identifying information and potential liability to the association for some kind of like cyber breach or misuse of the information. And then interestingly, who can get the information once you provide it to the federal government? what are your thoughts on how can the association be protected in that regard?
When you give it to the federal government, it is confidential. It is not subject to people filing a Freedom of Information Act request
Right.
and getting it saying, I want to know about Happy Condo's board member. I want to know what her, driver's license number is or something. No, I can't get it through the FinCEN reporting, so that doesn't work. But I would be careful, Allison. We're talking about that information. If you are the person who is the keeper and filer for our association, I probably not going to email my driver's license to you or my date of birth, all of my identifiers. I might hand deliver it to you. So I've got to be careful with it on that side of it. I'm not just putting it out on the internet and hoping for the best.
One of the things we occasionally run into is a spouse has a restraining order against a partner or a
Mm,
spouse. And part of that restraining order is that no information is to be given to the spouse about the address, et cetera, et cetera. Um, Even if that exists, and to your point, Steve, that information has to be dealt with very confidentially. And in fact, in that instance, if a person's really uncomfortable providing their license with their address and so on, they can go on the FinCEN site themselves and file their own information.
right.
They don't have to give it to a third party.
Yeah,
So,
and here in Florida, personal identifying information is not accessible in terms of a records request. So I don't think this information would be accessible to other members.
Mm,
And, you could use encrypted messaging, we could probably have a whole course about that, right? But you might want to also talk to your agent about some kind of cyber insurance or at least have a conversation about that. So, at the end of the day here, we keep getting questions. Are associations really going to have to do this? We have a few months left before January 1, last quarter here.
yeah.
Is this really real?
David hopes so.
yeah, well,
Well,
it's real, and
uh,
I will tell you that the only hope that associations would become exempt um, is as a result of a lawsuit that has been filed by the Community Associations Institute, and I'm sure many of you are aware that that's a national organization that advocates for community associations. And several weeks ago, CAI filed a lawsuit in the Eastern District of Virginia seeking to have community associations exempted and also alternatively to find that the statute is unconstitutional. Now, some of you may be aware of I think it was an Alabama case in which an organization representing small businesses came forward and sought a federal trial court decision, which ultimately did determine that as to that entity and that entity's members, the statute was unconstitutional. That was not a national decision. It doesn't apply to anybody other than that entity and their members. CAI is hoping that either the court would agree that community associations were not an intended target of this legislation and should be exempted out, or that it's unconstitutional as applied to CAI and its members. Now, just one word of warning, if you're not a CAI member, it's possible that a court would find that only CAI's members would be excluded if it ruled in CAI's favor. Now, I have learned that this Friday, a hearing on a preliminary injunction is going to be heard. One of the reasons the Eastern District of Virginia was picked is because they have what is known as a rocket docket. They move cases very quickly. So that hearing will be held this Friday. Will there be a decision by the court on Friday? Quite likely, no. But we would expect that sometime after that hearing, could be in the weeks following, that there could be a decision one way or the other. Now, it's very hard to get a preliminary injunction. So even if you have a good case, very often a court will not issue a preliminary injunction, but it's possible. So, of course, we would let all of our clients know whatever the result of that is, and if there isn't, some kind of at least temporary exemption because of a preliminary injunction against the government from enforcing the law against associations, that would, for at least the time being, relieve the pressure of having to do this. So that's the current status of that.
And we'll certainly be advising our clients of any developments one way or the other on that. And David, also, I think you're aware there's some pending federal legislation. It's been pending actually since 2023,
Yes.
because I think Congress moves very slowly, and di the view on that probably is that that may not be successful this year. So
Right.
we may have to do at least one filing. We have great hope for it in 25. But if you are thinking that it's going to take that act of Congress, yes, it will, maybe. And it's not going to happen in 24, I don't think. So,
The interesting thing about that, Steve, is the House already passed a
mhm,
1-year extension by a vote of something like 420 to 1. I mean, when does the House ever vote
right.
420 to 1 on anything? But the Senate has not indicated a desire to really move it forward. We're in the middle of an election year. It's not the highest priority before the Senate right now.
And again, I always encourage clients to be politically active. And so if you know a representative in Congress and you happen to talk with them about this, please encourage them to pursue this legislation, because it would help everybody in the country who has a condo or a homeowner association, cooperative, timeshare, or anything else like that, that would otherwise be obligated to report.
So everyone should comply. They shouldn't wait it out, right?
And they should start getting that information together.
Yes.
I mean, even if you don't file until, late November, early December, make sure you have the information available to allow you to file.
Mhm.
Okay. So we have received many questions.
Mhm.
I don't know how many, but quite a lot. So I don't know, Steve, David, if you're up for it, we can do some sort of like rapid fire questions.
Let's do it.
Okay,
Sure.
I'm gonna start kind of scanning these questions, and I think this is a good one because we still are receiving questions. Does this relate to our association? We're a small HOA, 19 homes that has 38,000 in annual assessments. What are our requirements?
Comply.
Yes.
Exactly.
Next question.
For 99.9% of those of you watching today, you will be complying if you're a corporation with the state of Florida or New Jersey. I had a question about New York. Yes, you would be complying. And then we continue to get questions, and we get these questions all the time, not just only on this topic, but we're a nonprofit. You said we're exempt. That's just not the case, other than maybe the two that Steve mentioned. And Steve,
Yep.
you've been doing this a long time, right? So if you
Yes.
only had two, that shows a lot.
Yeah.
Those are charitable organizations.
Right. Right.
So
That don't even have to pay federal or taxes at all under any
Right.
circumstances. Now, most of you don't probably pay little or no federal taxes. That doesn't mean you're tax exempt. You still file a return. You still have to have your accountant go through the whole rigmarole as to show that you don't have taxable income. Different issue. You're not exempt.
So could be from an outlier here. Our 2025 budget will exceed 5.1 million, and we have 20 plus employees. Will we be exempt?
The 2025 budget or the 2024 budget?
2025, well, the question was 2025 will exceed 5.1.
Yeah, I think if you're under 5 million this year, you're going to have to file. Next year and going forward, if you stay over 5 million, then you're going to be exempt.
So we keep getting questions. Is this for the association or individual board members?
Yes.
Yes, both.
And it is for both.
Right.
So yeah, you have to report association information, you know, tax ID number, principal place of business, and then you also report what's known as beneficial owner information, which is going to be your board member information. There is that little quirk Steve mentioned very quickly, which I'll just readdress here, where if you have an association where 25% of the units, we'll just say, are owned by, you know, the same person, a bulk owner, that person is actually a beneficial owner as well. Doesn't come up very often, and a lot of times they're on the board anyway. So,
Right.
but if you're in that bucket here, that, you know, jot that down to come back to, and that is something where you may need to contact legal counsel if you're in that circumstance.
You know, one interesting issue, Allison, on this front is, let's say you have an association where one owner owns 50% of the units, and maybe they're renting the units, but they literally can control who's on the board. They may be that entity, the ABC LLC, who owns 50%, may be required to report because that entity has substantial control over what goes on in the association. Also, while the developer is controlling the board, the developer entity itself um, may have to file. Now, the interesting thing there is, and I don't really know the answer to this, is many developer entities would meet the 5 million plus, and particularly national developers, and 20 employee plus standard. So would that exempt them in connection with the association when they're controlling what's going on in the association? I'm not sure I have a good answer to that question.
Yeah, but with respect to the first example, if you have one owner who owns the, you know, majority, and even the law or the notes provide for the 25%, then they surely do have to be
Yes.
reported as a beneficial owner.
You know, one interesting question I came up, and I don't know that I know the answer to it, but I think this might apply more frequently in Florida. You have somebody whose permanent residence is in Canada. They come down, you know, during the winter months. They have a Canada driver's license. Can they use that as their identification?
Yes,
Yes.
there is a
Okay.
drop-down box to include non-US information for that purpose.
Well, there you go.
Yeah,
Great.
so it provides for both examples, but I just chose to highlight the more typical example here.
Sure.
Yeah,
So-
David, to your question though, that director, when he or she is in Florida, in your example, they have the Florida address, and then when they go back to Canada or wherever they're going back to, could be another state for that matter,
Right.
they have to again update the report,
Yeah.
the
That's a good
seasonal
point.
directors.
Anytime you're press changes. So just a couple more since we have a few minutes here, and thank you to everyone. I want, for those of you who aren't staying for the questions, once again, everyone be safe in this hurricane. We really wish everyone the best. If you have any after the fact storm damage from this hurricane, maybe Helene, Becker does have our association adjusting. You can go to www.associationadjusting.com to learn more about our services there. It's not only adjusting, remediation, storm cleanup type stuff, but back to this. Our architectural review board members considered part of this beneficial owners. I just want to restate, no, this is board members only. Is this Sunbiz? Did we comply by going to Sunbiz? Once again, no. Just to wrap up, this is a federal law requiring reporting for your association and your beneficial owners, which are your board members of the corporation. And with that, I know we're out of time. Steve, David, do you have any last words for our attendees today?
I think we've said it multiple times, but I'll say it one more time. Start planning to make the filing. It's not difficult. Get that information together and just make a determination as to who is going to do that filing for you. Your management company, your secretary, whoever it is, get that straightened out now. You can still wait to file, but get that information flowing.
Yeah, I'll join in that as well. And if you're in the line of sight for Milton, do evacuate, be safe, and take care of yourselves. The property will deal with that later. Be in touch soon. I apologize again for the background. That's because I did evacuate, and look forward to seeing you all later in the week.
Thank you. Thank you to everyone who was in attendance today. Once again, we'll have the presentation available after the fact if you want to replay or share it with your fellow board members. Have a wonderful day and please stay safe.
Goodbye, everybody.